but instead of looking at who produced it, like what humans were involved, we're going to look at how it relates to the original license grants. So this is where the grant definition is so crucial. So what this means is that if the technology primarily relates to the technology I licensed into the JV, then it's going to be mine. If it primarily relates to the technology Kathy licensed into the JV, then it's hers. And if the new technology relates to both of ours and mixed together, then it ends up in the purple bucket, which is jointly owned IP. Now, under US patent law, jointly owned IP means either of the joint owners can exploit it without permission from the other. And significantly, it means they could assign it, for example, or they further license it to a third party who could be a competitor to one of these parents. So for example, if Kathy and I own joint IP, she could go license it to my colleague down the hall. Imagine they're like my worst enemy. I don't have any enemies here at the law school, but imagine that. And there's nothing I could do to stop that if I'm just relying on default patent rules. So what I might do then is design contractual measures that prevent that from happening. So I might have anti-assignment provisions. I might have, I need to get to George's question, change of control provisions in the contract that address this type of issue. Because it's not just the question of like, I need to stop Kathy from assigning it to somebody. What if Kathy's company gets acquired by my colleague down the hall? That's equally problematic for me. So I'll design contractual provisions in the contract itself that try to address these type of contingencies